Good afternoon, everyone. My name is Mose, Karanja. I'm a research fellow in the Center for Intellectual Property and Information Technology and staff in law school of cybersecurity regulations at the continental level. From the African Union perspective, what they've been doing, I'll say they have been doing. And so the reason I say they have been doing is that as much as they have been a lot of information feeding Addis Ababa and all these meetings they have been organizing, we are frustrated about at this point because last weekend, 26/27, the African Union adopted, the heads of states, they signed and adopted the draft convention that was presented to them. I mean, the document could be improved with the proposals that have been raised from across countries, like sectoral opinion that are research-based. As we speak at this point, the African Union Commission, they are expecting 15 countries to ratify and deposit the instruments in Addis Ababa, and 30 days from that, they become part and parcel, or at least according to our constitution, which it's very clear. So it's a critical time for the Internet Governance Forum, the Internet Society, not just in Kenya but globally, to focus on this document in its own way, directly and indirectly. Angela spoke about the positives about the document, which we also feel it was necessary because the nature of the Internet and operations around cyberspace are by their own nature transnational. So we need an international perspective around it. But when meaning against which it was conceived. Now, let me just go through why we feel this on what we researched on and this on what we researched on and what we proposed from the institute. The dilemma on managing crime, because the criminal is one step ahead of you because he's not bound by law, he's breaking the law, of course. But then you have to follow the law as you're following it. But this is one provision that we felt maybe include. But then maybe most controversial, and I'm happy that the Human Rights Commission is here, and we have at least other stakeholders from the civil society, has to do with the protection of personal data. The convention provides that your data can be accessed for public interest. Now, this public interest is not defined. There's no statutory definition in the convention, and as such, you're just giving a blank check. Do whatever you want. I mean, anyone can interpret this as, and this has been documented. You remember May 2010, as Kenyans were reading themselves to vote during the referendum, some chapter characters introduced two words to the Bill of Rights, the draft that was sent from Parliament to the Attorney General to the government printer. They introduced two words. One can enjoy, the Constitution provides for the enjoyment of, human rights if they are not limiting national security. Now, just those two words could have given the Constitution a whole new meaning, and that Constitution will actually not be as good as we want it to be. Now, without clearly defining what you mean by personal interest, then you're giving just this program some role of government, because governments that are working very hard to improve on the everyday liberties of the people. This is something that should have been defined at least by the convention. That notwithstanding, then maybe that's on civic relations, but then on international relations, we talked about the transnational nature. And this is one of the reasons I know Angela was very happy that these guys were doing something around cybersecurity, so that we can have at least a continental approach that can be used. But then, what they don't go ahead and do is to give some legal grounding around it. they are still depending on mutual legal agreements. Now, research shows that the reason international crime has been so hard to prosecute is because countries are always dilly-dally around handing over their citizens for prosecution in another country. So the mutual legal agreements are really not the best way to now go with the second convention. Maybe some legally binding grounds, around extradition, double criminality. These are issues that at least the convention should have taken care of. It will just pile up on the other EU conventions that rely on mutual legal agreements for the effectiveness. And we all know how that goes. But then, basically, I don't want to, the theme of the meeting today was about county governments. And I'm being to just wrap up, and actually I was wrapping up, and the connection between Addis Ababa and a county somewhere, maybe Machakos. What does this mean to Machakos? Okay, yeah, the heads of states like that, it should go to cabinet and parliament, and then we ratify it. So what? Now, this will affect each and every activity that happens online. Actually, this is the one thing that traps all of them. It's the one thing to rule them all. Now, when you think about this thing, county governments, and of course their executives in each and every county that are tasked with the ICT management, this is where they should now at least act on. They should push their governments, at least, you don't have to agree with our recommendations, but at least we are saying, this from our research, this is what's happening. At least go through them, see how much you can at least improve on this document. And then we can ask our Ministry of Foreign Affairs to do something about this. And then Article 37 of the Convention gives space for amendments. And this document, the battle is not lost, but maybe we should move with haste because changing a convention is very hard, especially a continental one. Then you really have a hard time. And for a continent that is adding 167 mobile phones every day, the space is just big. And this is something at least we can do. So with big data comes big responsibility. Please do something about it in your own personal capacity. Write to your legislature, do everything you can at least to improve on this convention. Thank you very much.
Thank you very much, Moses. Very interesting.